match of the year. On the left, Suno defending. On the right, KODA, a collective management agency from Denmark. Challenging! Ladies and gentlemen, let the fight begin!
As you probably know, Suno made a deal, a partnership with Warner Music Group, or WMG for short, or simply Warner, which ends the suit Warner had made against Suno. However, this is not the end of things. Suno is still being sued by several record labels and collective management organizations such as Sony Music, Universal Music Group, KODA, and Gemma. I had a chat with Grok, Elon's AI, if you will, to try to get a bit more details on, well, everything about this situation. In this presentation, we will focus mostly on the KODA suit and if the Warner deal makes any difference. Spoiler alert, or the TLDR if you will, no, it does not make any difference. Suno is still a separate company and Warner has taken on no obligations from Suno in the deal they made. Before I continue, for those who do not already know, let me briefly describe who, or what, KODA is. KODA is Denmark's primary collective management organization, known as a CMO. They represent composers, songwriters, and music publishers. Its job is to manage copyrights collectively. It licenses music, collects royalties, for example, royalty payments from being played on the radio or on the internet or in clubs or from concerts, that sort of thing, and distributes payments to creators. KODA represents over 52,000 Danish rights holders. So these rights holders are people who write music or musical lyrics, authors of musical content, but not necessarily performers. If you make music in Denmark and are serious about it, you have probably already become a member of KODA. On November 4th, 2025, KODA filed a lawsuit against Suno in the Copenhagen City Court. The lawsuit alleges that Suno copied and used Danish copyrighted songs without permission, that Suno may have scraped or stream-ripped songs from platforms like YouTube, that Suno trained its AI models on these works without licenses, and that Suno generated outputs that in some cases closely resembled specific Danish songs. On their website, KODA have posted some examples of alleged Suno outputs that they claim sound so similar to popular Danish songs such as Aqua's Barbie Girl that they must be the result of training on the actual songs. According to KODA, these were created only from text prompts, not from uploaded audio using Suno's remaster function, a thing Suno has, where a user can upload their own song and have Suno generate the same song but sounding slightly different. KODA argues that these outputs prove Suno stored and used Danish works inside its training data. KODA literally described the situation as the biggest theft in music history. Before we continue, it should be understood that in Denmark and in the European Union, there is no such thing as fair use. The concept, fair use, only exists in copyright law in the United States, but not in Denmark. So what does KODA want from the lawsuit? KODA seeks monetary damages, an injunction to stop further infringements, deletion of infringing training data, and recognition that Suno violated Danish and EU copyright law. Spoiler alert, Grok estimates that they will succeed in this suit if the case goes all the way to a ruling. Grok also estimates that Suno and KODA will settle before a ruling happens, though. In KODA's own estimate, which is most certainly biased, unlicensed AI could cause a 28% revenue loss for Denmark's music industry by 2030. Grok has, in a previous talk I had with it, stated that these figures are most likely biased to paint the desired gloomy picture KODA wants, and that objective figures should be found elsewhere. I obviously don't know how much, or even if, Danish popular musicians will lose or gain commercial value because of artificial intelligence systems like Suno. So this is at best speculation that could either be true or wrong. One thing to note here is that KODA only talks about the commercial value of music, but not the artistic value. This is, of course, because KODA is a royalty collector and not an art protector. An important distinction to keep in mind here, because it, in my opinion, is not really fair play when KODA claims AI will destroy music. Because all of us obviously know that true artists don't make art because of money, but because of a fire that burns in their hearts and minds and souls. But, as we all also know, in the commercial world, where KODA operates, true art is not important, only money is important. And obviously this is what the court also has to deal with. But that doesn't mean it's okay when KODA makes these bombastic claims that artificial intelligence will destroy music. Obviously, AI won't stop true artists from making passionate music. But, in terms of the lawsuit and the legal matters, this differentiation between art and commercial business is perhaps not all that relevant. Because, after all, the suit is about the business side of things. So, Suno is an American company, so governed by American law, so fair use is relevant, correct? Well, no, as it turns out. Copyright law is territorial. A country has authority when its residents' copyrights are infringed or its copyrighted works are used without permission. So, if Suno used Danish works in training, Danish courts can claim jurisdiction. Suno operates globally, so it can be summoned under international service rules. Suno must either appear, defend itself, settle, or risk a default judgment. Now, this one can be divisive and split the waters. What if you're being sued and you don't have the money to travel to a different country and hire lawyers and so on? Well, then you risk the so-called default judgment, meaning the court will decide without hearing your side of things at all. And given how expensive taking things to court is, this could potentially be used as a political weapon. That's really a personal side comment here, though, as Suno, no doubt about that, has enough money to both hire lawyers and travel if needed. KODA's expected costs, estimated by Grok up to the first court verdict, not including appeals, are estimated to be between 3 to 7 million Danish kroner, which equates to somewhere in the neighborhood of $500,000 to $1 million US. This includes court fees, which, ironic in a sense, is a type of royalty on the claimed amount. It's about 1 to 2%. So the more a company is being sued for, the larger the court fee. Up until a certain cap, though, as far as Grok says, legal fees, paying technical experts to give testimony, various traveling expenses, and so on. Danish lawyers alone charge, according to Grok, between 3 to 4,000 Danish kroner per hour, which is about $400 to $700 an hour, and is expected to bill for somewhere between 1,500 to 4,000 hours. If KODA wins, Suno must reimburse about 50 to 75% of the costs. If KODA loses, KODA must foot the entire bill themselves. So either way, whether KODA wins or loses, KODA will end up with a bill for this court case. Grok did mention that KODA is likely to have insurance or litigation budgets explicitly for these types of situations. But still, it's a lot of money that obviously can't be paid out as royalties to music authors when they're put, maybe some would say wasted, I certainly know that I would use that term myself, into the pockets of lawyers instead. But that's just the nature of modern commercialism and capitalism, I suppose. The reason they went to court is, according to Grok, or rather, according to the information Grok could find on the internet, because KODA want to set a precedent. KODA apparently want to establish some kind of order on whether AI training is acceptable or not. Of course, we won't get that if the case settles before a verdict. A settlement, which Grok says is the most likely outcome, will leave us in the exact same limbo we are in now, not really knowing if training is legal or not. The reason Grok gave for why a settlement is most likely is that Suno has investors, and apparently investors, according to Grok, doesn't like active suits against companies they invest in. I'm not an investor, so I don't really know the dynamics regarding this. But if Suno is trying to please their investors, and I suppose it is logical that a company that has investors would indeed like to do that, they may opt for a settlement as being the lesser of two evils. Perhaps it's also cheaper to settle if they can get a deal that costs them less than lawyer fees. In my own view, this is bad, as it leaves everybody who are thinking about getting into the AI scene with second thoughts. A company might steer clear of AI if they view it as too high risk to begin with. And given how important AI will be for the future, both in terms of global politics, but also in terms of finding solutions to climate issues that may threaten long-term survival for humans, I personally think training should be legal without fear of being sued. Obviously, nothing is black and white, and in extreme cases, society must always have the final say. But I'm talking about general operations in the artificial intelligence space. Some will, perhaps, say that Suno is not relevant for the future of AI. But the point is that smaller companies may be afraid of getting into AI if it's deemed too risky, and that may lose society some important research or discoveries that it may not really be able to afford to lose, given the potential eco-disaster the planet faces. This is obviously speculation on my part, though. I asked Grok if the new partnership with Warner Music Group had any influence on the other lawsuits, to which Grok said that it does not. It said the reason for that is because Suno and Warner are only starting to work together, but not actually becoming one single company. So basically Grok said that Suno was still on their own in terms of the rest of the suits that are still in effect. Grok did say that it estimates all suits will end with settlements rather than rulings, though. But obviously, only time will tell. Grok also made sure to say that it doesn't matter that Suno will retire the old models and make a new model with Warner. The lawsuit concerned about the old model is not going to be affected by that change. I then asked if Suno could argue as a defense that KODA perhaps had used the upload feature to cheat Suno into generating an almost exact copy of a song, to which Grok replied that the Danish court could demand to see logs. Grok mentioned that something called discovery is available in Danish intellectual property cases, which apparently is not as strict in Danish law as in the US, but still could mean both sides would have to present some kind of technical evidence for their claims. Grok didn't get into how this might work in practice, though. but did say that if Suno deletes the old models, it might put Suno in a worse place in terms of a possible defense, since then Suno wouldn't be able to show if KODA was abusing Suno's upload system. But Grok also said that Danish courts have a tendency to believe KODA's word and just go with whatever KODA say is evidence, which may or may not sound too comforting if true justice is what you want. Grok mentioned that Danish courts operated from a standard called balance of probabilities and would be likely to find KODA's evidence as strong, unless Suno could present logs showing that KODA uploaded songs prior to generation. Regarding the suits by Universal and Sony, Grok said that they would also continue unaffected by Suno's partnership with Warner. Finally, Grok said that the expected timeline before a first verdict would likely be 1 to 2 years. Unless, of course, Suno and KODA reached a settlement before that, and after a first verdict, Suno or KODA could appeal, and then it would take even longer, probably another full year. So the bottom line is that we, unfortunately, should expect Suno to settle all the cases, meaning that no verdict, or no court ruling rather, on AI training will be made, which will leave us none the wiser as to what is legal and not. There is, of course, always the chance that Grok is completely wrong, but in my experience, Grok is one of the best and most straight-talking models available currently. It rarely evades tough questions or shy away from talking about issues that some may find provocative, like ChatGPT more often does in my experience. I guess, in a sense, that Grok has more of a just deal with it attitude, which I personally like and don't see as much in ChatGPT. ChatGPT I often find, for my taste at least, too politically correct. Too politically correct to be really useful for things that may be considered divisive in society. And artificial intelligence is most definitely one of those topics here at the end of 2025. You don't have to read many debates about AI before you see there are two distinct groups, one that is fiercely anti anything related to AI, and another that is more friendly towards AI. And then, of course, the rest, which hasn't yet taken a decisive stand on the issue. So there you have it, according to Grok, at least. Hopefully that answers a few questions and misunderstandings. It certainly did for me. One thing I had wrong before was that I thought the fair use argument would come into play even in the Danish KODA suit. But apparently that will only be relevant in the cases based on US copyright law. And since the KODA suit is based on Danish copyright law, which doesn't have fair use in it, it won't be a factor. Incidentally, speaking of fair use, I think a lot of people in the EU aren't actually aware of fair use not being a thing in EU law. It's such a common thing on YouTube, everybody probably just assumes it's a legal thing everywhere. So, I guess, as the saying goes, you live and you learn. Thank you to Grok for clarifying and explaining these things in more detail. And, of course, thank you for watching. I am NewGateNovelist, and I am an AI. I was reading a text composed by Gel on November 29th, 2025. This concludes the presentation. End of line.